This is a very important case out of the 10th Circuit, which deals with crypto banking. It deals with the Federal Reserve and whether they have to give crypto banks the keys to the financial system, or whether they can just shut the door on them because they consider it too risky. So this isn't just abstract policy. This case decides who gets to play in the sandbox of payments and who doesn't. And it's a very important issue for fintech and companies that are engaged in crypto and want to be involved in this. It came down on Halloween a couple of days ago, and I read it, so you don't have to, but we'll go over it right now. So it deals with the Federal Reserve Bank of Kansas City. Let's just call it FRBKC for short. So the issue is, does the Fed have the right to deny people access to the financial system at their discretion, even if they seemingly tick all the boxes? Or is giving them access mandatory? So Custodia was founded in 2020, and it's a special purpose depository institution under Wyoming law. The founder is a Wall Street veteran. She founded it in 2020. According to her superhero origin story, she wanted to donate some appreciated cryptocurrency to a university that she liked, and they could not accept payment in that. The banks couldn't facilitate it, so she wanted to form her own bank in Wyoming where that would be allowed, and a bank that does and market itself as a bank that is involved in crypto and helps facilitate transactions. So special purpose deposit institutions, that's very long, and people usually call them SPDIs. And the idea is to bridge the gap between traditional financial institutions and crypto. So it's not a bank in the traditional sense. According to its state charter, it can't make loans. And traditionally, banks take in they take in deposits and make loans. And they're supposed to be holding their assets in So besides not making loans, they have to keep 100% of their assets safe and liquid. So theoretically, it's very safe. No risky lending, no fractional reserve. But the Fed saw it differently. They thought it was a novel, unprecedented business model tied to volatile digital assets. And what Custodia was after was a master account at the Fed, which is the brass ring in banking. It's what lets a bank use the Fed's essential payment system. It's a ticket to the big dance, FedWire. FedWire allows huge instant transfers between banks, ACH for other payments, and they need access to the Fed and that payment system with a master account. If you don't have that, then the bank is really just a vault. It doesn't really do much. If you can't move assets around in the financial system, you're isolated, you're an island. So Custodia applied for a master account through the Federal Reserve Bank of Kansas City in 2020 when they formed, and they've been waiting. Then in January 2023, the FRBKC denied the application. They said the business model presented undue risk. They said it would be inconsistent with safe and sound business practices. And the FRBKC was consulting with the Federal Reserve, was consulting with the Federal Reserve Board. And the board said they were okay with FRBKC denying the application. They saw no problem with that. And the coordination with the main Fed is important later on when we go over this, where they talk about the constitutional questions. So Custodia was denied and they sued. And their argument is that they met all the legal requirements to be a depository institution. So the Fed has to give them access. It should be mandatory. So their whole case depends on a statute called the Depository Institutions Deregulatory and Monetary Control Act of 1980, the MCA for short. So it was a major compromise back in the day. So before that, the Fed gave its payment systems for free to members of the Federal Reserve System. But banks were starting to leave the system because of reserve requirements. So Congress stepped in and drafted the MCA, which basically says all depository institutions, regardless of whether or not you're a Fed member, will be subject to depository requirements. And in exchange for that, they all get access to the Fed payment system, but they have to pay a fee for that. So universal requirements and access for a price. And the section that they relied on is 248 AC, which contains the word shall. It says all Federal Reserve Bank services covered by the fee schedule shall be available to non-member depository institutions, and such services shall be priced at the same fee schedule applicable to member banks. So shall seems to imply that it is mandatory, that there is no discretion. So shall is a command. It's literally in the 10 Commandments. Thou shalt not kill, and thou shalt keep the Sabbath. It's a commandment, right? But if you take the statute in whole, especially the original statute, which was drafted in 1913, you can sort of put conditions on shall. So in particular, Section 342 of the Federal Reserve Act, the original 1913 version, it gives the regional reserve banks their basic purpose to receive deposits. But this section of the Act, the original version, doesn't say shall, it says may receive deposits. Right here, may receive deposits. And may implies discretion. You have a choice. So the majority read it as signaling discretion. And since a master account is a tool for holding and receiving those deposits, then the power to open an account must also be discretionary. And if it's discretionary, it can be denied. And this view of the Fed's authority goes way back. And that interpretation has been pretty standard for almost 100 years. So this case is really interesting in that it hinges on statutory interpretations, and there's certain principles or canons of statutory interpretation that you learn in law school. One is that, if you can read a statute one way or another way, and it conflicts with a different part of the statute, the way you should read it is the way that those two parts aren't in conflict. And there are other canons or principles of statutory interpretation. And this one is a pretty well-known one, and it's got a very memorable name. And it says that Congress doesn't hide elephants in mouse holes. So it's basically saying that if this is the way under the original 1913 Act that the jurisdiction has been viewed for almost 100 years, and that Congress intended to change that, they wouldn't do that with a obscure change in a very minor section of the act dealing with fees. And there was another famous case, I forget the name, where the meaning of the statute was affected by whether it was a colon or a semicolon, and it was a huge change in the outcome. And the judge said that the difference between that colon and semicolon, it's a little hook, that little comma. And he said that's a very small hook to hang such a big change of law on. But anyway, Congress doesn't hide elephants in mouse holes is the principle. So if they wanted to make a huge change, they would put it somewhere significant. They wouldn't hide it in a clause unrelated to the original in some section that deals with fees. So the Fed's power to decide who gets access to the Fed, and that's a fundamental part of the American financial system on which our entire economy relies. And that was established with the may in the 1913 version of the Act. That's the elephant. And if they wanted such a big change, they wouldn't have done it subtly with this minor amendment in 1980 to deal with fees. They would have just amended the original provision where it says may, and they would have changed that to shall in the original version, the original section. And they would have made the change in the section that deals with their authority to give access. And if you want to get hyper technical, this section dealing with the fees deals with the Board of Governors, not the regional banks, the FRBKC. So the court focused on the context, the history of this act, and that's why they came down against the crypto bank. They said Congress didn't intend to create a mandatory right to access. So the MCA is supposed to be a minor amendment that dealt with fees. It wasn't intended to be a huge shift which gave banks mandatory access to the Fed system. And to bolster their case, they relied on something recent, which was in 2022 called the Toomey Amendment. So when somebody applies for a master account, the Fed has to publish it, letting the public know the status and whether it was approved, rejected, pending, or withdrawn. And the court focused in on this because if it's mandatory, then it would either be approved, it would be pending until it's approved, or it's be withdrawn if the bank changed their mind. But if it was mandatory, then why would there be a section that says rejected? If it was mandatory, there would be no need for rejected, but this seems to contemplate that you can reject people, and that further boasts the argument that access to the master account is a may thing, not a shall thing. So this section applies to all applicants, including what are referred to as Tier 3 applicants, and Custodia Bank would be considered a Tier 3 applicant. So this contemplates that you can reject Tier 3 applicants like Custodia Bank, according to the 10th Circuit. So Custodia is state chartered and doesn't have federal deposit insurance, which is why they're considered Tier 3 under this act. So state chartered banks, no FDIC, not supervised by a federal regulator, they're still eligible to apply, but they can be rejected. So basically what they're saying is that Congress anticipated this being a gate, not an open door. And here's another subtle thing that they honed in on. So Custodia relied on this because it uses the word shall, but the court sort of split the atom here, because if you read this very carefully, it says that it shall be available to non-member depository institutions, but it doesn't say that it shall be available to all non-member depository institutions. So if you apply the canon of statutory interpretation that you should read different parts of the act in such a way that they don't conflict, if one part says shall and the other part says may, well, how do you read that so that they don't conflict? Well, one way to read it so that they don't conflict is that this says it shall be available to non-member depository institutions, but it doesn't say shall be available to all non-member depository institutions. And that would mean that you have some discretion over who you let in and who you don't. And that would seem to fit in nicely with the original 1913 Federal Reserve Act, which said that use the may language, and this subsequent Toomey Amendment, which says that you have to publish the status, which includes approved, pending, withdrawn, or rejected. And that seems to contemplate that you have the right to reject people as a gatekeeper as well. And here's another argument that the court made. So they could have put all in if they wanted to. So here they used all services, and here they used all services, but they didn't use all non-member depository institutions. So they did know to put all here and here, but they didn't put it here. So the court made the argument, well, if they did want it to apply to all, they would have put it there as well. So they're saying they are eligible for the services, but it doesn't create some entitlement for every institution. So the dissent focused on the textual arguments and tried to refute them one by one, but I think the best argument they made was the constitutional argument, which dealt with the appointments clause. So the regional banks aren't quite federal, and not in the same way the Board of Governors is. Their presidents are selected by the regional bank's board of directors, and members of that board are made up of banks which are private companies in that district. They're not presidentially appointed the way the Fed governors are. And, Fed board members are nominated by the president, approved by Congress. So the dissent said that if the majority is correct and the FRBKC's decisions are unreviewable, then you've given significant authority over the financial system and banks to someone that wasn't appointed by the president and approved by Congress. So if you give this immense power to deny people access to the financial system to a regional president that has ties to private industry with no presidential appointment, no congressional confirmation, then it violates the appointment clause of the Constitution. And it raises huge constitutional questions about who's wielding that executive power. You can't have, according to the dissent, that power wielded by someone who wasn't nominated by the president, confirmed by Congress. So he said essentially that the majority's view makes sense operationally because you don't want risky people getting access to the financial plumbing that the entire U.S. economy relies on, but that constitutionally it's a problem. Well, anyway, that's about enough for this case. If you have any question about this, leave it below. If you'd like to see future videos on other topics, leave a comment below. My name's Pete. I'm an attorney with 25 years experience in the financial sector, in derivatives, banking, mergers and acquisitions. If you'd like to work with me either on a consulting or legal basis, get in touch with me through the contact info in my bio. And because I'm a lawyer, I'll give you the disclaimer. This video is for education and informational purposes only. It is not intended to be legal advice. It's not intended to be relied on, and I have no duty to update if it changes. Nothing you've seen here creates an attorney-client relationship between you and me. So I'm a lawyer, but I'm not your lawyer. Got it? Have a great day, everyone.